the reason why this was brought to me from one of my constituents that deals with unemployment insurance, and he brought me some stunning cases of people getting benefits for misconduct at work that they thought were just causes for termination. One of them fell asleep on the job. I want you to put an image in your mind briefly about a nurse falling asleep and potentially not being able to do something for your loved one that happens to be in the hospital. That's the type of situation. Obviously, you can't leave that nurse continuing to do that if she does it she or he does it more than once. Another employee wipes off the top of a filing cabinet violently after being reprimanded. Another one urinated off the top of a public school building while school was in session. Could have been added to the sex offender registry for exposing themselves to a child, but was terminated and got unemployment benefits. That's why we brought this bill forward. Government Accountability last year did a public hearing, and the Department of Labor came and testified that they were just following the direction of the courts. The courts have overruled the referees on numerous occasions, and the department is just trying to follow the precedent the courts set. That's why we decided to try to change the definition of misconduct. And this law has been in place. Similar law has been in place in Florida, and we believe this is the right way to go to redefine misconduct. I'll be glad to answer your questions, but I do have at least one person that's going to come testify and may be able to answer more of your questions.
Thank you very much, Senator, for bringing this bill back before us. Hopefully you got a chance in the interim to travel down to Florida, educate yourself on this issue, certainly in like the Orlando area, maybe like a certain geographic place.
I'm sorry, Mr. Chairman, I was not able to travel down to Florida. I wish I would have taken that opportunity, but I did not.
I heard the Magic Kingdom, this is like a big issue. You should check it out.
Sounds like a good road trip this summer.
Very good. Any questions of this witness before the bill sponsor before he calls his first witness? Seeing none, go ahead.
I believe Tracy King with the Missouri Chamber is here.
Mr. Chairman, members of the committee, Tracy King here representing the Missouri Chamber of Commerce and Industry. We'd like to go on record in support of the bill. We did work with Senator Krause on the legislation last year, and we appreciate him finally again this year and following up with this important piece of legislation. You know, Richard Moore talked to you about and gave you the bleak picture of the Second Injury Fund, and unfortunately it's not the only challenge Missouri employers are facing, in that the Unemployment Trust Fund is also insolvent, and the Department of Labor actually puts out projections about every quarter. It's a 10-year projection that they do, and the fund as of December 2012 shows that Missouri employers still have $527 million in Title 12 loan balances that they will have to pay back. And it also shows that the deficit will be carried forward all the way to 2016. So not only we have to pay it back, but it's ongoing, and that doesn't even include the interest. So just really quick to talk about Unemployment Trust Fund and how this works is the feds, when they put the program together, they said they would give there's a 6% tax on employers for employees' income up to $7,000. Now, if a state decides to administer their own unemployment, they would give employers in that state a 5.4% tax credit. We call it the FUTA tax credit. And so, in essence, what that leaves is about, on federal taxes, about 0.6%. So $42 per employee is what an employer pays in federal taxes. And then there's state taxes, which are calculated based on your experience rating. So, in essence, the law also says that if you borrow money, you have 2 years to pay it back. And if you don't, they penalize you by reducing that tax credit. And that reduction starts at it's 0.3% each year that you don't pay it back. So employers back in 2011 got notification in November that they were going to have to pay this, that they were going to have this reduction in their FUTA tax credits, which increased their tax. And they started paying that in 2012. That was a 50% tax increase on their federal unemployment taxes. And then in December, or in November of 2012, they were notified that the next 0.3% would be added in for 2013, and they're starting to pay that now, which is 100% of a tax increase. There's interest that's added onto that also that they have to pay through a state surcharge, and by 2015, that amount is all the way up to $84, which is a 200% tax increase on their federal unemployment taxes. So as you can see, this for many employers, this is pretty critical in a time when they're trying to hire more employees. Their unemployment taxes are going up. Even if they've never laid off an employee or fired an employee and had an unemployment claim, their taxes are increasing. So in looking at this, I think there's several ways that we can attempt to reform unemployment laws. And the first way is by addressing the tax issue, which you actually did, the General Assembly, back in 2011, when you took the number of weeks employers had to pay from 26 to 20. We were the first state to enact that into law, and now almost every other state's coming through and trying to reduce that also. You can look at reemployment and workforce training and education. So how do you get the employees back to work again so they're not utilizing the unemployment? And then you can look at the integrity of the program, and that's what Senate Bill 28 does, is it addresses the integrity in which the program was set up to give financial assistance, which is 100% paid for by employees. And I know many people are confused about that and think it works like a health insurance where you pay a little bit with your paycheck and then the benefits are there. But it's 100% paid for by the employers to give financial assistance to employees who are laid off through no fault of their own. And so that's what Senate Bill 28 does. You know, the senator mentioned several pretty egregious examples on sleeping on the job. You know, we had an example of an employee forged their diploma so that they could get a job, and it was found out they were given unemployment benefits. Stealing, which was actually caught on camera. We've had examples of inappropriately touching coworkers, and they've been given unemployment benefits. So I think most of us, especially for those really egregious examples, can agree that this is truly misconduct, and these employees should be denied, but unfortunately they're rewarded, and I think this is raising concerns with the employer community throughout the state. So in looking at not only the cases over the last year, but also doing some research, I just want to leave with you a couple of conclusions. First of all, I think the definition of misconduct is too broad. Our definition right now will not rise, nothing really will rise to the level of misconduct. And secondly, the burden of proof is so high that it's almost impossible for an employer to prove that the employee had committed misconduct. You have to prove that they consciously did it and that they intentionally did it. So for example, on sleeping on the job, the case that Senator Krause talked about, the court ruled that there was no way that the employer could say that the employee proved that he really meant to do it, or prove that it was a conscious decision to fall asleep at the job. Sometimes when you're sitting there, you doze off. And so that's the difficulty that we have with the current definition. And finally, I leave with you that Missouri is not alone. There are quite a few states that have the exact language, word for word is our definition. It looks like it started out as model legislation that was put in place, but many states are actually going back and they're reforming them. The states of Minnesota and North Carolina commissioned a study to look at the problems and maybe recommendations on how to shore up their unemployment insurance trust fund and what to do with the laws. And in fact, Florida, as the senator mentioned, actually passed legislation. They had the exact definition we currently have. They passed it in 2011. The employer community is very happy. They've had it in place just a little over a year. And in fact, with just 3 months after the definitional changes, they had a savings of $360,000. They are not out of compliance with the federal regulations, and hopefully I'll have before the committee a letter from the Department of Labor saying so. So the changes that we're making are very similar to the changes that were made in Florida. And in fact, really the difference was just some tweaking that we worked with some employment law attorneys who tried to make it more similar to Missouri law. With that, I just want to add, it's all about the integrity of the program. We want to make sure it works so that it's there for people who really need it. I'd be happy to take any questions.